Today, I'd like to share some practical advice for foreign companies on how to reduce the risk of disputes when using freight transportation to ship goods from China to overseas destinations. Many companies focus heavily on product quality and price negotiations, but they often overlook transportation risks. In reality, a significant number of international trade disputes arise not from the products themselves, but from problems during shipping. Here are several precautionary measures that I strongly recommend. First, clearly define the Incoterms in your contract. One of the most common mistakes I see is that parties simply write FOB China or CIF New York without fully understanding what those terms mean. Incoterms determine which party is responsible for transportation, insurance, customs, clearance, and the transfer of risk. For example, under FOB terms, the risk generally transfers to the buyer once the goods are loaded onto the vessel at the port of shipment. Under CIF terms, although the seller pays for freight and insurance, the risk may still transfer at the port of loading. Therefore, both parties should specify the applicable Incoterms version, such as Incoterms 2020, and clearly define the port and responsibilities to avoid misunderstandings. Second, verify the qualifications of freight forwarders and carriers. Do not simply rely on your supplier's recommendation. Before appointing a freight forwarder, conduct due diligence. Check whether the company has a good reputation, proper licenses, and sufficient experience handling international shipments. Whenever possible, use established freight companies and request copies of shipping documents, including booking confirmations and bills of lading. Fraud involving fake freight forwarders or unauthorized carriers is not uncommon. Third, purchase adequate cargo insurance. Many buyers assume that the carrier will compensate them if goods are damaged or lost. Unfortunately, this is not always the case. International conventions and transportation laws often limit the carrier's liability. In many cases, the amount recoverable is far below the actual value of the goods. Therefore, cargo insurance should be considered a necessity rather than an optional expense, especially for high-value products. Fourth, pay close attention to shipping documents. Commercial invoices, packing lists, bills of lading, and certificates of origin should be carefully reviewed before shipment. Even small discrepancies in product descriptions, quantities, or consignee information may result in customs delays, additional storage charges, or disputes over ownership of the goods. Electronic copies should be preserved, and original documents should be securely managed. Fifth, inspect the goods and preserve evidence. Before shipment, arrange quality inspections and document the condition of the products with photographs and videos. Upon arrival at the destination, inspect the cargo immediately. If damage or shortages are discovered, notify the carrier, freight forwarder, and insurer as soon as possible. Many claims are rejected simply because the claimant failed to provide timely notice or sufficient evidence. Sixth, include dispute resolution clauses in your contracts. Do not wait until a dispute arises. Specify which country's law will govern the contract and whether disputes will be resolved through arbitration or litigation. For cross-border transactions involving Chinese suppliers, arbitration institutions such as SIATAC, HKIAC, or SISC are often good options because their awards are widely enforceable internationally. Finally, maintain complete records. Keep emails, purchase orders, shipping instructions, inspection reports, and payment records. In international disputes, documentation is often the key factor that determines whether you can successfully recover your losses. Conclusion: international freight transportation is an essential part of global trade, but shipping disputes can be expensive and time-consuming. By clearly allocating risks, selecting reliable logistics partners, purchasing insurance, preserving evidence, and preparing proper contracts, foreign companies can significantly reduce the likelihood of costly disputes and better protect their commercial interests.